Now coming to the third big change, and for that I'll read out a clause from the 2025 bill that made headlines on social media. People just read this part of the bill and made their own conclusions and said that the bill was underwhelming, that it was unjust against the non-Muslims. What was that clause? The clause said that provided that the existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act 2025 as waqf by user will remain as waqf properties, except that the property wholly or in part is in dispute or is a government property. Now this clause was very clear about one thing, that the government properties do not remain waqf properties, even if they are registered. However, the people had this question about the retrospective impact on properties that were disputed, and this is where the waqf by user concept becomes very, very important. For those who don't remember, in part 1 we discussed that the waqf by user clause was introduced under the Nehru government in 1954. What is waqf by user? For instance, you own a land parcel, or the land parcel is adjacent to your house. One fine day, someone walks up to that land parcel and starts offering a prayer. That goes on for 1 year, for 5 years, for 10 years, 15 years. And someday in the 20th year, someone says that this land parcel, irrespective of its owner, irrespective of its value, irrespective of its utility, is being used for a religious purpose, and therefore verbally I can dedicate it as a waqf property, even if I don't own it. This was waqf by user, that any land can be dedicated as a waqf property purely and purely based on how it was being utilized, even if the utilization was not happening from the owner. And this clause says that if these waqf properties are not registered, they cease to be waqf properties. Now here's the interesting part. Around 37 lakh acres worth of land falls under the waqf. 22 lakh acres is almost waqf by user properties. 8.7 lakh worth of properties under the waqf. Over 4 lakh properties are waqf by user properties. Now this is where the word registered in the clause becomes very, very important. When we hear register, we hear proper documentation. So one would assume even if a verbal dedication has been made, the documentation would be proper. But that's not the case by waqf by user properties. All these properties were being verbally dedicated just based on the long-term usage of these properties. Now tomorrow if there is a government land which often lies vacant for a lot of years, a group of people start offering a prayer there. Will they be in a position to claim it as a waqf land after 5, 10, 15, 20 years? Absolutely not. From a economic angle, that doesn't make any sense, but that is what waqf by user was allowing, and this act, this clause was introduced in 1954. The 2025 bill does away with it. That is where the waqf by user now comes to an end, and the verbal dedication will no longer be valid. If you have the paperwork, the property belongs to you. If you do not have the paperwork, now is the time for a legal dispute.